19th July, absolutely.
Correct?
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings. Minutes of meetings. Well, will my lord be allow me to just place that before your lordships? Just give it to my lord, please. Yeah, we'll give you the copy. This is on 18th July. The matter was fixed in this court on 20th July. The petitions, all petitions were to come up for directions. So from 21st of June to the 18th of July, nothing happened. No faction, no claim for faction. Now, let's, on 18th of July, just kindly come to page 7 of this compilation.
What is this?
Oh.
Minutes of meeting of?
Minutes of the meeting.
Of Shiv Sena.
Translation of the Pratinidhi Sabha. Now, what do you have here? Your lordships may take it, there is no summons for any meeting, no venue for any meeting, no time for any meeting, no signatures obtained at the meeting, nothing. Just note that, my lords. No time, no place, no date is given 18 July, no summons. I suppose this is a meeting of the Pratinidhi Sabha of the Shiv Sena. So it must be known to everybody where the meeting is going to be. Summons must be sent like we sent to them. Right? What they do is they give a translation of the minutes of the Pratinidhi Sabha. And in the minutes, they show some resolutions have been passed. Minutes, as your lordship will know, is after the meeting. It can't be before the meeting. Right? It has to be after the meeting. So there is the minutes of the Pratinidhi Sabha. And there are also minutes of the Karyakarni. That your lordships will see at page 10. Again, minutes. Again, when it is held, what time is it held, where it is held. Yes, they say it happened, it is held in Bombay. I guess, someplace in Bombay. They must have known. Now, so 2 minutes are placed before the Election Commission. These 2 minutes.
Subsequent minutes also of what date? 27th?
27th of July. That's even more interesting. Well, just note the note 27 July. And then go back to the petition that they filed. It's very interesting. These are the 2 documents that they placed, nothing more. Plus, of course, appointment of people. We're not into that. Convenience volume 2. Page volume 2. This petition is filed on the 19th of July. Just mark that, Malaj. This averment is made when the petition is filed on 19th July. And just above that, Malaj, Roman 25 at 697, the last 2 lines of that page, if your lordship has that.
Just what is this document that you pointed out?
Whereby the Rashtriya Karyakarni has affirmed, now please note this, has affirmed the election of the petitioner as the Shiv Sena senior leader and Shiv Sena Mukhya Neta. Now this is on 19th July and the minutes of that are 27th July. I showed that to your lordship. This petition is filed on 19th July. He says that the petitioner was elected as the senior leader and senior Mukhya Neta. The minutes are dated 27th July. This is what they filed, Manas. So 19th July, they could not have known what would happen on 27th July. And that also minutes of meeting. These are the only 2 documents with the commission. That's why I read paragraph 15. These are the 2 documents with the commission in respect of to prove that there are 2 factions arising. And second document was submitted during the course of hearing, but be that, I don't want to go into that. I'm just only interpreting 15. This is the documents in their possession, information on the basis of which Election Commission is satisfied that there are 2 factions within the party. So minutes of meeting. Well, let's.
Where are the minutes of meeting here in this compilation page, PDF page?
Yes, we just shown that one. Here and it's not there. That's why we.
It's not an annexure.
That's why I gave that to your lordship.
Mr. Sibal, but that's not an annexure to the petition. Are we right?
It's not here, Malad. That's why I gave your lordship.
No.
Where are those
minutes?
I'm just, let me hear, my lord.
What you have read of this para 26 Para 25 refers to annexure P5, which is the minutes of the meeting of the.
We haven't put it, Malaj. That's minutes.
We don't have. But the petition also does it and close it is what we are trying to
Yes,
understand.
yes. That was handed over, Malaj. It doesn't say. That's why we gave it to your lordship.
That is of the 27th.
Yes. So now it says 27th. This petition is filed on 29th. They did enclose the second one. They didn't enclose. First one they've enclosed. P5 they enclosed. So, Malaj, these are the two documents with the commission. Now, if you read paragraph 15, this represents two factions in the party, the minutes of meeting. That's how the election commission, Malaj, got jurisdiction, according to them. And Malaj, this is a final order. This is kindly just look at it. I can understand if the commission says lead evidence. I can understand, please prove your case. On this basis, a final order is passed, which is the subject matter of challenge in the other proceeding. That's how they got the symbol. So what does the governor do? What does the election commission do? And this is the evidence. And then we have to, we must ensure, we must trust that all institutional authorities function in accordance with the law. And if this kind of manipulation takes place, Malaj, in the processes of institutional decision making, where we go, Malaj, where we will go, I don't know. I am done, Malaj. I just want to make one non-statement. I stand here not for this case. I may lose it, I may win it. That's another matter. But I stand here, Malaj, for the protection of what is so close to our heart. Institutional integrity, and to ensure that constitutional processes survive. Otherwise, if your lordships endorse such a position, it will be the death knell of what we have cherished since 1950. Thank you.
Thank you. Yes, Dr. Singhvi.
Yes, I would wish to take your lordships principally to some very interesting underlying juristic principles. Because the lordship has now seen the facts for 2 days, so I'm not going to repeat. Juristic principles which should impel your lordships to decide this matter here and not consider the various options or suggestions of sending it back to the speaker. That's going to be the bulk of my argument. But Balas, I want to start with where we are ending up, because I was here the whole morning and I heard the very important question which fell from the bench, and the Honorable Chief Justice in particular, about the role of the governor. And I'm going to repeat anything, I'm going to try and give a different facet. Well, this is a very unique and a strange case. And I would say from this side, a sorry case, where your lordships has double whammies and triple whammies. Let me explain how. My Lord Willis put the question of the governor's role. And in one sentence, the question is that if your lordships if the governor found that there is something to be decided by way of unstable majorities, even if you exclude 39, why can't he go and have a trust vote, etc., or a decision on the true majorities in the confidence of the House? Well, it's the first thing when you start on that query has been perhaps not given sufficient weight. And the first thing is that your lordship's fundamental rock-solid principle of interpretation of constitution and statutes is that if intentionally a constituent assembly in its amending power of the constitution deletes something, your lordship gives full effect and scope to the intendment behind that deletion. That is what is axiomatic. It is obvious a puny contract or a statute, much less a constitutional amendment, where your lordship's intention is to give effect to that intention.
So para 3 has been deleted.
Now, para 3 deletion is not a small thing. There are debates, there is a SOR, the Constituent Assembly, the Constituent Parliament in its constituent capacity said, look, we must delete it. Why this case is bizarre is that there are at least two circumventions of that deletion directly by high constitutional authorities. Circumvention 1 is clearly this way or that way, whether the governor can do it or not do it, the lordship will decide separately. But clearly and specifically, the governor is acting on a presumption of a split. in whatever way he's acting. Now, as the governor, most of all is supposed to know the constitution. All of us are supposed to know the constitution, and ignorance of the law is no excuse, much less ignorance of the constitution. There is no system, and I'm not talking of your lordship's narrow question of trustworthy, non-trustworthy. There is no basis on which your lordships can reconcile and harmonize the factual invitation and oath giving on the one hand with the legal deletion of para 3. That's my proposition. The two are irreconcilable. And that is a very major constitutional sin underlying this whole supposition and context. The second makes this even more bizarre. There is no counterpart to curiouser and curiouser. It can't be bizarre and bizarre. There is a direct finding in not one but many paras of the EC order that this is a split. I'm not asking a lordship, Justice Shah is right. We are not on the appeal on that. That's not the point I'm arguing. I'm on the context, People are here going around merrily on the assumption of a split, then the lordship might as well wind up the 10th schedule, the constitutional amendment, the deletion. What's the point of it? I'll give the paras, there's more than 4 paras or 3 paras in the EC. Just give the paras. Yes. I'll give. Now, therefore, your lordships and those cases don't have to be given to your lordships of elementary forms of interpretation that if I delete something, your lordship gives effect to the deletion. I'll supply them, not necessary to do it. The second answer, or the second response in the larger context of that query. So this is the first response. The second is, your lordships decides cases, not that your lordship decides the narrowest of narrow issue, your lordship decides the whole context. But your lordship doesn't decide beyond the context of a case. Your lordship is very careful, otherwise the things of whiter and all that come in. And your lordship doesn't have time to spend on hypothetical questions.